It's a great honor for me to be here, great privilege, and I'd like to thank the organizers, especially uh, Mr. Prashant Bhushan, for giving me this honor. I was reminded of my professor, Dr. Madhav Menon, who taught us, many of us sitting in this hall, uh, back in the 70s, 50 years ago. Actually, it was the 50th year this year after I entered law college at Delhi University. And one thing he did in Bangalore, maybe Mr. Sondhi has experienced this, is that he would start off some of the sessions for the first year students by having two professors who totally disagreed with each other. You may remember that. And then they would say totally opposite things. And that's how he would introduce students in a very unusual way to law in their very first year and first classes. So I thought of him because perhaps his spirit was with us, because we have today two professors who are going to take totally opposite views, Professor Mustafa and myself, and keeping up that tradition of Professor Menon, not in everything, but certainly in his proposal that the law minister should be part of the collegium. I could not disagree more strongly personally with that proposal. But to place this in context, and also place in context some of the references he made to the historical material on the role of the collegium and the appointments of judges, I think we need to focus. He's raised the question of what are the deeper causes underlying the interference in the government. I think none of the speakers, perhaps with the exception of Chief Justice Lalit, because he is in a very unique position and he cannot share with us or address with us, what on certain topics he has to maintain his reserve, and I respect that and I accept that. But the other speakers are all accepted and agree that there is interference. There is interference, and the word interference means is having a role which you are not supposed to have, and a role that is not wanted. That's the literal dictionary meaning of the word interference. And so when we say there is interference, we think that the government is having a role in judicial appointments that it is not supposed to have. That is not welcome. And it is also true, I think, as Mr. Sondhi said, that this happens in many ways. It's not just through the formal communication between the collegium and the government, but through many subtle and not so subtle, explicit and implicit ways. And we need to look at interference, as Mr. Sondhi invited us to do, in a much broader context of de facto interference and the role of the bar and the politicization of the bar, which Mr. Sondhi talked about, is, I think, an extremely important issue, which I think very deeply affects the question of interference in judicial appointments, not just larger judicial independence, but just in judicial appointments. And so that's accepted. Now the question before us is, in what way, what kind of reforms to the existing system can help to deal with this interference, to counter this interference? And in particular, the reform of the collegium system, either its abolition and replacement by a commission, or retaining it and reforming it. What would be the best way to resist interference? I don't think there is any doubt in anyone's mind that no one, including Chief Justice Lalit, would brook any interference in the judicial appointment process by the government. When I say interference, that which it is not supposed to do and which it is not sought. So we are all agreed on that. So when we look at the problem as responding to interference in judicial appointments, and we look at the role of the collegium or an alternate system, and Justice Lalit told us that there is no better alternate system, and therefore we have to go with the collegium system. We have another session to look at alternate systems and approaches, and I'm not going to transgress into that area. I'm just going to look at interference in the system by the government, which is really the issue before us. And so that there is interference is accepted. What we need to discuss is what are the causes and consequences of interference. Why is there interference? And in the very limited time available here, I'll just mention a couple of points. First, a set of facts. I did some quick looked at some numbers, and numbers are always very interesting. There have been 111 judges, according to the website of the Supreme Court, who've been appointed to the Supreme Court during the UPA and NDA period. That is from the from May 2004 till today. 111 judges, of which 56 were appointed during the UPA period of 10 years and 55 during the NDA period, which is now 8 years and 9 months as of now. So we have almost a similar number of judges being appointed by UPA and NDA. And if you look at this and say, what is the impact of any kind of interference on this, some interesting facts begin to emerge. One is that, now here we come into interpretation, which could be quite subjective, but what we want to look for is, are there judges being appointed who are politically biased in either the 10 years of the UPA system or under the NDA's 8 years and 9 months? And let's not look at their internal outlook and way of life, which is a very, very complex, but let's look at their judgments and look at the objective material that we can see. Now, when I looked at this material from my own perspective, and I'm not going to say names because there's no time to discuss all that, I found that during the UPA period, there were 6 judges who we could broadly put as what I would call constitutionalist judges, who believe in the supremacy of the Constitution. I won't use the word liberal or progressive. I'd say constitutional judges who firmly, deeply believe that all decisions have to be made exclusively on the touchstone of the Constitution and nothing else. And I could find only 6 names that I could put a hand on my heart and say, yeah, I would rely. If I had a case and the judge had to decide it, I would have absolutely no doubt in my mind that this judge would decide it only on the basis, maybe in my favor, maybe against me, but only on the basis of his or her best understanding of the Constitution and not influenced by any other source of law other than the Constitution or sense of policy. It's very interesting that this number actually goes up to 9 under the NDA regime, in my view. Now, we may disagree on numbers, we can all do this exercise. It goes up and does not go down. Why? Not because the NDA government sponsored such people who will swear by the Constitution. To the contrary, the topic I suggested here to the organizers was packing the judiciary to overthrow the Constitution. So I believe that what's going on here is packing the judiciary to overthrow the Constitution. So it's not because of the government that this number went up, because there was resistance to what the government is doing from the collegium. And the collegium during this period, particularly before 19, like they had made efforts in the case of Mr. Sondhi, in the case of several others, they made in the case of Justice Qureshi, whose name so far has not been mentioned, but he's a great martyr of the system. He should also should rightfully have been in the Supreme Court. Justice A.P. Shah is here; he should rightfully have been in the Supreme Court. They're all martyrs of the system. And but leaving all that aside, the collegium resisted and was able to, when they saw the pressure on the other side was increasing, I think some members of the collegium, not the collegium as a body, it's a transitory group, saw to it that some constitutionalist judges would actually go up. And the number didn't go up by a huge amount, but certainly a few. This is only 6 and 9 out of size 55 and 56. But if you look at another figure, how many judges are committed to go outside the Constitution and look at Sanatana Dharma or Vedas or ancient Indian legal principles as the basis of their decision? They may be religious people, they may believe in the Vedas, they may worship, but when they sit as judges, the first group are looking only at the Constitution and the law, applying accepted principles of interpretation. But are there judges who we believe, as students of law, we're all students of law here. We may have different ways of working in law. We're all students of law. How many judges would actually look beyond, genuinely, not because they're influenced by the government or they're seeking office after, appointment after office, but they would genuinely, based on their own bona fide believe that the real source of justice must come from Vedas and religious texts and not the Constitution. That number, I could not find anyone actually appointed by the UK who, from their work, from their written work, maybe one or two borderline cases, we could say they are in their judgments looking beyond the Constitution as a source of law. It's a source of law. But this is 9 after the NBA has come to power that I can count. 9 judges, of whom 5 are still on the bench, and I won't name anyone obviously, who explicitly in their judgments indicate that we have to go beyond the Constitution. And that's what happened, for example, in the Ayodhya judgment. Some of the judges went beyond the Constitution, beyond the law, to decide the case, to adjudicate the case in front of them. So this number of judges who are traditionalist judges or theocratic judges, who will find the source of law in religion and not in the Constitution, has sharply increased. And I believe this is the first phase of a 2-part attempt strategy to achieve the stated goal of establishing Hindu Rashtra by 2047, when we will celebrate the centenary of the Republic. Not by overthrowing the Constitution, but through interpretation by the Supreme Court of the Constitution as a Hindu document. And to do that, the first phase involves appointing judges who are open to looking to theological sources as a source of law. And the second phase, which will now begin, is to appoint judges who will identify the source. And that began, for example, in the hijab judgment, where one of the 2 judges actually said that Panth Nirapeksh means religion and not dharma, and said that the Constitution does not say Dharma Nirapeksh, it says Panth Nirapeksh, and says that dharma applies to the Constitution and actually says in the judgment, Constitutional law is dharma. The Supreme Court is saying, and what he means by dharma is Sanatana Dharma. So he's saying that our constitutional law is Sanatana Dharma. The first time that Rubicon has been crossed. That constitutional law is dharma. He's not saying this rhetorically. He's saying we have to take into account dharma in applying the law, and therefore hijab is religion. Someone sent me a video saying, we are having Homa in Karnataka schools, but not hijab. Homa is allowed, but hijab is not. And I thought to myself, the reason is hijab is considered religion, Homa is considered as dharma, because it is for the benefit of all of the earth and mankind and all that. So that's dharma, that's okay. Now, which religion does not consider itself as dharma and not narrowly as religion? Right? So we are now opening the doors to actually go beyond simply looking at sources, generally speaking, as we have done in the past, broad statements like this of dharma, to being much more specific and saying, we recently had a High Court judge specifically refer to Vedic sources and say that is the source of particular provisions in the law. So this is the next step. Once that is completed in the next 24 years, I think we would be able to safely say that India is a Hindu theocracy under the same constitution as reinterpreted by the Supreme Court. So the idea behind here is to hijack the judiciary and establish a Hindu theocracy, and I certainly do not want a voice personally, purely personally as a student of law, I do not want a law minister sitting in the collegium making sure that this agenda is fulfilled. When the collegium today, by the first number I gave, that those who are constitutionalists, that number has gone up because the collegium has recognized. We have many members, we have at least a few people here who have been members of the collegium. The collegium is not, they can't speak about it, but they're not blind to the risks and the dangers that the country faces. And they are trying to build in some resistance now because they see the danger. This is the first point. Second point is very brief, and then I'll end. I have 4 minutes left before 12 noon. The second point is the core problem here is that our constitutional project and vision is in conflict with the vision and values of the oligarchy that runs this country. This country is run basically by an oligarchy because most of the power is in the hands of just 4 communities in all fields. They had British and Muslim forces to counter them, but after independence, there is no community in the country that can counter them in power and influence. And so there is no countervailing force except the constitution. And this misalignment between the interests of in many countries, including the reference to Pakistan, the constitutional vision reflects the vision of the oligarchy. There is no real conflict between the oligarchy and the constitution. But here the constitution deliberately, by introducing democracy, equality, liberty, dignity, socialism, secularism, is directly challenging the worldview and the philosophy of the ruling Hindu oligarchy. And that conflict first drew a reaction in phase 1 of India's judicial independence, where the judiciary stalled the constitutional program by just striking down one after the other progressive legislation that reflected the constitutional vision in Article 38(1) of creating a new social order, not economic or political order, in which justice, social, economic, and political shall inform all institutions of national life. So stalling. That stalling drew a reaction from people like Justice Krishna and Mohan Mangalam. That is what we can read Mangalam out of context. But what he was saying is stop stalling the program and vision of the Constitution. And Krishna and the gang of 4, as they are lovingly called, Justice Bhagwati, Justice Chinnappa Reddy, and Justice D.A. Desai, 4 of them together, they tried to align the judiciary's vision with the constitutional vision. Then came Mandal in 1991. And I believe it was not by accident that it was within the next year of that, 1992, that the collegium system was established. Because it was part of the reaction to Mandal to remove the control of the policies of the country, which they saw a resurgent OBC coming into executive and the legislature. They had to be insulated from the judiciary. So a government, an executive that would be controlled by a different social group, not from the oligarchy, had to be resisted. So it's not by coincidence that the collegium system emerged, and at that time there was no resistance to the collegium system from the political side. They worked together to ensure that judicial appointments were still controlled by the elite. And today, if we look at the social composition of the Supreme Court, we see that it has been protected without any diversity. From a social point of view, from a gender point of view, it's better, but I saw a very widely circulated social feed with a picture of 5 respected and wonderful jurists, 5 women judges in the Supreme Court. But the comment being circulated in the widely amongst common people in the country was, they see 5 women, all I see is 5 Brahmins. So there is a genuine concern about lack of diversity, and that leading to lack of representation. And so this project of protecting the judiciary socially has succeeded. And that is a space, that is what is creating the vulnerability. And now the government is taking this one step further and saying, look, we are going to use the judiciary. Like Mohan Mangalam wanted to use the judiciary to align the judiciary with the constitution. I want to use the judiciary. We want to use the judiciary to destroy the constitution. and completely build a theocracy here. And so in this context, and see, this is a reflection of the bar. The oligarchy controls not the judiciary, it controls the bar. And it's from there that the domination comes. You go to any high court, you'll find there's a small 2 or 3 communities that dominate the bar and the bench. So going forward, my conclusion is that it will be very dangerous to give this government, whose mission, explicit mission, is to overthrow the present republic and establish a Hindu Rashtra, any role in judicial appointments. We must preserve and protect the collegium, because that is our best hope for now, under the present circumstances. This is not the time to hand over any power or role in judicial appointments into a government that is bent upon destroying the constitutional mission. Not that the earlier governments were any different, but this one has a clear ideological agenda. But in order to protect the constitution, the collegium must consciously see that its job is to protect the constitutional vision against attack. And it must consciously choose and put on the bench those who are committed to protecting the constitutional vision against this subversive attack that is taking place now. And the collegium, to strengthen the judiciary, must diversify. Religion, caste, region, economic class, in all these respects, we want to have a rainbow judiciary, where everyone feels this is our judiciary, we are represented on it. I'll conclude by saying in 1930, in the first roundtable conference, Dr. Ambedkar presented a memorandum to the first roundtable conference where he put 8 safeguards, brilliant safeguards for the depressed classes. And one of the safeguards was adequate representation in the legislature. Safeguard number 4. Safeguard number 5 was adequate representation in public services, including executive and the judiciary. And he proposed, he did not use the word reservation, that was brought in the Constituent Assembly. This is the root of reservation. He proposed that recruitment into public services must be so regulated as to ensure the due and adequate representation of all communities. Because that was essential, not just scheduled caste or depressed classes, but all communities must have due and adequate representation. He said, we are here, the depressed classes, of course for a responsible government, he told the Roundtable Conference, but we are here also for a representative government. No one else demanded a representative government. The demand for a representative government has been forgotten. And so we have an oligarchic government. So the collegium must ensure that the constitution is defended. The collegium must ensure that we move forward to diversify the judiciary and make it a representative judiciary. And that will provide the foundation for the judiciary to be a guardian, not just of the constitution, but of the values of the constitution. How many judges stand up and say, we are guardians of the constitution? Many. How many stand up and say, we are guardians of democracy, guardians of socialism, guardians of secularism? Very few. So we have to safeguard the content of the constitution, not merely its formal structure. Thank you very much. I think I may have exceeded by 2 minutes.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.